Whether it's you or a loved one that's been accused of a felony, this by law means it's a charge that will result in more than a year in custody if you're found guilty. Now, it's very important to understand that this is a process that is going to take longer than you are going to want. The first issue we want to discuss is bond. If somebody is still in custody, we want to make sure that we try to get a bond, which you're entitled to constitutionally. The only reasons why somebody wouldn't be entitled to a bond is if they have a history of not appearing in court when they're asked to, if they pose a risk to the community around them, if there's a risk that they're going to intimidate witnesses in their case, or if they're likely to recommit another felony again. So again, your history is going to play a big role in whether or not we can get a bond. The next step in a felony case is a preliminary hearing. If somebody is in custody, there are certain charges where a judge has to decide bond, but only after they hear the facts about the case. Preliminary hearing is like a mini trial and is something that we're going to show up in court to be with you or your loved one. Preliminary hearing also means that the detective that's investigating your case will have the opportunity to present the facts. Now, this is not like a trial you see in the movies. Hearsay evidence is allowed. And the other thing that's important to understand is that the burden of proof is different. We've all heard proved guilty beyond a reasonable doubt, and that applies to trials. But when we're talking about a preliminary hearing, the level is 50% plus 1. Are you the right person? Is what you're accused of sufficient to demonstrate a felony charge? And is it more likely than not that this occurred? Unfortunately, that's the basic standard of proof for a preliminary hearing. So oftentimes these cases are simply rubber stamped by the judge, but we want to find out the information about what you're being accused of. The discovery process is where we get all the evidence from the state disclosing what evidence they have against you in your case. If we don't have the opportunity to represent you in the preliminary hearing, it could be months before we learn those details. So we always want to get included in the preliminary hearing process if at all possible. Once we get past the preliminary hearing, unfortunately, we are in a post-COVID era, and that means that the courts are overwhelmed with cases. Your case may take 6, 12, even 18 months to get to the next stage of the case, and that's the arraignment. The arraignment is the opportunity for the state to formally present the charges to you in a document. Now, this is important constitutionally because from the point of arraignment forward, the state can't add more charges. So they can continue the investigation from the time of the preliminary hearing up until arraignment. The charges may change a little bit, but at that arraignment, we now know what you need to be protected against when it comes to the defense of your case. And lastly, of course, is a trial. Now, 98% of cases don't go to a trial, which is why our sales department is not going to include a trial fee with your initial quote. And that's because we don't want to scare you away with some big number that probably will never come to pass. What we will be talking about is what it takes to get through the arraignment process and potentially negotiate an agreement with the district attorney in your case. Now, if the matter does have to go to a trial, we'll sit down and have another strategy session to talk about the benefits and the hazards of moving forward with a trial, and unfortunately what the additional price is going to be. We can't decide that right now because we don't know if there's going to be experts, we don't know what the evidence is or how strong the state's case is or what the likelihood is of getting an agreement. So we're going to set the trial price aside for later on, and if ultimately you decide you don't want to use us for a trial, you're of course always welcome to change attorneys. Look, we want to be honest with you. We want to be upfront. We know this is very important for you and your future. So we're going to be an open book. We're going to discuss with you what your options are. We want you to ask us the questions that you have because there are no stupid questions when it comes to talking about a felony charge. Thank you so much for trusting Rohan Law. That's why we say we want to be your best friends on your worst day. We know you don't want to hire us. We know you don't want to be calling into our office, but we want to make sure that we protect you and provide you with the best possibility for the best future ahead. So thank you, and we look forward to talking with you with our sales department and discussing how we can help you with your case. Your best friend on your worst day.